We might kick off. Good afternoon, good morning, wherever you are, and thank you for joining us for today's HK45 Fireside Chat. My name's Duncan Watson. I'm a partner at Quinn Emanuel in Hong Kong, and I'm also on the executive committee of HK45. And I'll say a few brief introductory welcome remarks before handing over to the main event. HK45, as you hopefully already know, is an organisation that's designed to really bring together younger arbitration practitioners in Hong Kong, around the region, around the world, and give them a forum to meet each other, to learn from each other, and to practice their skills in what we hope is a supportive and friendly environment. The Fireside Chat series that today's session is a part of is one of our sort of flagship events that we're very proud of. It provides us with an opportunity to speak with senior practitioners from around the region and around the world, to hear about their journeys, their experiences, to hear in particular their advice for junior practitioners, their thoughts on the future, and in particular their thoughts on diversity issues in the profession. Today we're very pleased to be joined by Louie Ogsimer. Louie probably needs no introduction to most of you, but he is one of the leading international arbitration practitioners in the Philippines and indeed the world. He's a partner at Romulo, a leading Philippine firm where he heads the international arbitration practice. He has experience as counsel in some of the biggest and most high-profile arbitrations in the region, including commercial and investment treaty arbitrations. In my personal experience, I can say that he's also a hugely generous supporter of and mentor for junior practitioners. I am very grateful for his friendship over the years, and I'm very much looking forward to hearing from him today. I'm also very pleased to introduce Louie's interviewer for today, Ms. Kitty Jung. Kitty is an associate in Sherman and Sterling's arbitration practice in Hong Kong and is really one of the most impressive up-and-coming associates in the city. Kitty is also a driving force on the HK45 committee, on which I've had the pleasure to serve with her for the last year or so. So on that note, I'll hand you over to the main event, and I'll hand you over to Kitty and Louie.
Thank you very much, Duncan, for your very kind introduction. And again, welcome everyone to join our seminar, and thank you again for Louies for joining us today. As Duncan mentioned, Louie currently leads the international arbitration practice at Romulo, which is one of the top law firms in the Philippines. And I think you have actually had a very long career at Romulo. When did you first join the firm, Louie?
I joined the firm in 1999. So I'm trying to avoid incriminating questions, but since you started off with one, then I think I have to stay factual. So I joined the firm in 1999, specifically July of 1999.
Yes, and wow, so now about 20-something years later, you are now the head of the litigation and arbitration practice at the firm, and you're certainly one of the go-to person for anything arbitration related in the Philippines. So I'll start by asking you, could you tell us a little bit more about what brought you to the practice of arbitration in the first place? I imagine the practice of arbitration was not as popular back then as it is today in the Philippines.
Yes. Well, first of all, I'd like to thank HK45 and HKIAC for this opportunity. But to answer your question as to how I found my way into arbitration, it's actually a funny one. It's kind of incriminating, but since I said I will be factual, then it's a very interesting story. I was a first-year lawyer in Romulo, and I was still in my small cubicle. And a partner approached me and asked, Louie, have you done arbitration? And so I said, because prior to joining Romulo, I had been with another firm, a smaller firm, because my thinking was, I want to join a small firm, get my hands and feet wet immediately before I transfer to a bigger firm. So I did handle one case there, but one construction arbitration, but it got settled. So of course, I told the partner, I know a bit of arbitration. And so he goes, okay, that's okay. That's good then. Can you please prepare? We have a meeting at 1 o'clock. It was past 12 p.m. at the time. It was, we have a meeting at 1 p.m. It's about arbitration. It's an ICC arbitration. So I said, well, okay, I'll study about it. So I studied ICC arbitration, the ICC rules at the time. And when I entered the room, the partner goes, so the client was there. Apparently, it was a long-time client and friend of his already. They have a good relationship. And he goes, oh, this is Louie Ogsimer. He is our expert in arbitration. So, that was how I started. I started with being introduced as an expert. And true enough and good enough, the questions by the client was all about the ICC rules. They didn't ask about, they were still unfamiliar with the ICC rules in arbitration. And so a lot of it, we didn't have much of Google at that time. You have to read through through actual books and the actual rules. So that's how it started. It turned out my 1 hour preparation paid off, because I did sound like I really knew what I was saying. But 20 years now, I teach the subject. I've done a number, but again, I hope my clients don't get to listen to this, especially that client of mine who was I was dealing with. But they ended up liking our firm and referred a lot of other arbitrations after that.
Yes, back at that time, I imagine, were there a lot of experts in arbitration?
There was
at that time.
I don't want to say there was none, but it was, in fact, our firm didn't even have an arbitration department way back then. So it was something, it was prior to the passage of Republic Act 9285, which is now the governing law of arbitration. We had already a law, a 1953 law, which was Republic Act 876, which was a bit outdated and has been then relegated to just for domestic arbitration, and is now being revised. So you can imagine there was no the Hong Kong, Singapore was not yet a recognized arbitration hub. It was all Hong Kong, and so even in the Philippines, there were some, but it's not compared to now. It would look like there was no such thing as arbitration at that time. It would look like there were some factually, but as I said, even our firm didn't have an arbitration department at that time.
Right. I imagine the subject related to arbitration was not something that you learned or was taught at that time in law schools yet. Yes.
I teach international commercial arbitration and private international law. Private international law is a bar subject. International commercial arbitration, I started teaching it probably 12, 13 years ago, but it was relatively, I wasn't the first one to teach it in the Ateneo, which is one of the law schools in the Philippines. And it was a fairly new elective at that time. So when I was in law school, there was no such subject as arbitration.
Yeah, I can't imagine. Then, based on what you have experienced and witnessed during your decades of practice in the Philippines, how has the practice of arbitration in the Philippines changed over time based on your experience?
It's actually changed dramatically, especially with the passage of Republic Act 9285 in 2004, or the ADR Act of 2004. Because with the passage of RA 9285, the Philippines, through RA 9285, adopted the UNCITRAL model law and as the governing law for international commercial arbitration. And then after RA 9285, the Supreme Court passed special rules on ADR, which applies specifically to ADR-related disputes, setting aside enforcement, refusal of recognition of arbitration awards. And this happened in around 2009. So all the changes were laid down. And because of these changes, more and more arbitration came into the Philippines. It was also a function of education. we started offering it in law schools, and people saw the benefit of arbitration, and especially in the Philippines, where we have our own fair share, like in some jurisdictions also, of judges who are either lacking in competence or impartiality, or worse, both. But with the development of arbitration, even the judges have become better. They have become more competent. They have become more familiar. We still have our fair share of improvement to do. But since I started in 2000 to now, it has been really different. Even the Supreme Court decisions of the Philippines and even foreign investors we've seen have really embraced international commercial arbitration, as opposed to going to court in the Philippines as a mode of dispute resolution.
Is there any areas in the practice that you would like to see that could be further developed or reformed in terms of the practice of arbitration there?
Yeah, I think in so far as international commercial arbitration, I think it's really the adoption of the UNCITRAL model. The Philippines is also a signatory to the New York Convention. So, and the Supreme Court decisions have so far been predominantly pro-arbitration. And I think the area that we would probably need more development is one in the area of technology. And this, hopefully, pandemic, we have been experiencing one of the longest lockdowns. We've been in lockdown since March of last year. And in the Philippines, when you go to court or when you have a hearing virtually, once you enter a building, you have to wear a face mask and a face shield. So, and sometimes you lose that signal, not every time. And for me, what is important is that the availability of the sufficient internet speed should not be a function of the resources of a firm. So we are lucky that I belong to a firm which can afford the fastest internet available, which matches most of the internet speeds in other jurisdictions in the world. But when you talk about opening up arbitration to almost everyone, especially to solo practitioners who sometimes can afford only a certain speed, then that is something which, in a way, does not open up an equal playing field. So hopefully the government, not just in the Philippines, but in jurisdictions which also have the same experience, that the government will invest in infrastructure like that, because it does go into leveling the playing field, not as a means, not based on resources of the council, but everything should be fair, and it just becomes a matter of diligence and industry of the lawyers in preparation for the case. So I think that's where I would want an improvement in the Philippines, if not for the rest of the world, especially with this experience we're going through.
Yes, I think the reality of the pandemic and certainly opened up a lot of discussions regarding technology and access to justice issues. Yes. I just would like to go back to your personal experience for a little bit more. You've handled a lot of commercial investment arbitration cases throughout your career. Is there any particular case that is particularly memorable or has a special significance to you personally?
I would like, because when my very first arbitration, the one that I mentioned earlier, was also the thing that, and this is something probably that the younger lawyers would welcome hearing, that after that first arbitration I handled, it was an arbitration that was seated in Singapore, but at that time, there was also an epidemic. It was at the time, there was a SARS epidemic in Asia. So the parties agreed to change the hearings from Singapore to Australia, to Melbourne. And I had to, that was my very first time to fly out, not just very first time to fly out for work, but to fly out of the Philippines.
Wow.
And I remember that the client was, we were representing the foreign investor against a domestic company. And I remember I was in a meeting we were in a call with the client. They were in Australia together with their Australian counsel, and they were asking, perhaps you can send a lawyer to Australia to help us out in preparing our submissions, because the governing law, the substantive law of the dispute was Philippine law. So I was telling the client that the partner was saying, let us know who you want, and I was saying, our partner so and so is actually a walking encyclopedia insofar as Philippine law is concerned. And then the client goes, actually, Louis, we were hoping you would be the one to fly in. Any young lawyer would have been excited about that, but in my mind, I don't even have the proper wardrobe to travel to Australia going into winter. The only temperatures I've experienced in my life was anywhere from 27 to 32 degrees Celsius. So that was exciting. But on top of that, very different experience was also the learning, being able to work with international counsel, and the international counsel we were up against, but more the international counsel we were working with, were really top notch. And for a young lawyer to be able to experience that, I was in Sydney for like 3 weeks. And I was really dealing with engineers, international counsel, a Queen's Counsel, and you learn a lot really by doing. That's really what most young lawyers do. We learn by doing. So I think that's one very memorable experience.
Yes, it sounds like your pathway to arbitration is arbitration found its way to you.
Yes, yes, that is correct.
Yes, for many of the people who are listening, and for many of the students and young practitioners out there who might be interested in starting a career in arbitration, but might be struggling to get their dream jobs right away or get their foot in the door. For example, they may be in a jurisdiction where the arbitration market is very small. Do you have any advice on how they can take that first step, on how they can first get their foot in the door?
I think the most, again, this is personal to me. So I know that to each person, they look for a different path towards whatever it is that is their goal, either in their lives or in their careers. But to me, as you correctly pointed out, I didn't even know about arbitration when I was thrust into it, and I think the key for any young lawyer is still really preparation and hard work. It sounds cliche and it sounds scary, but it's really the sleepless nights while you're still young that will teach you how to handle arbitration. And as with most things, as with a bad reputation that is spread by word of mouth, I'd like to think that is the same with good reputation. If you show that you are dedicated, you work hard, you're willing to pour in long hours, and you really study the material and the law, the people that you work with will appreciate that. And so from that very first case I had, that singular case I had led to easily, in a span of 2 years, 3 to 5 other arbitrations in just a matter of 1 or 2 years. And quite frankly, I was thinking, what did I do right? It's probably just because of my sense of humor that the client and my collaborating counsel like. But it's that multiplier effect. When I'm being presumptuous here, I think, but I'd like to think that probably that good word that was passed on by the first account got passed on to 5 other people, and those 5 other people, if you do the right thing again, will pass it on to other people. It's a long, arduous process, but eventually you will get there.
Yes, for sure. In addition to putting in the hard work, building a good reputation, is there any common mistakes that you have seen that for young practitioners who just first start in the field often make?
Oh, well, that's the good thing about. Let me premise my answer by saying that, as we all know, in arbitration, it's very different from litigation. It is a more informal atmosphere. And what I like about it is that you don't have to be rude and arrogant in order to put your case across. And I see some young lawyers sometimes do that. And I think I can't really blame them, because sometimes it's a function of preparation. You're very eager to orally argue your first case or your first few cases. You want to impress the client, and so on. But I think as you mature in practice, whether it be in arbitration or litigation, we should always remember that the dispute resolution process, its objective is justice. And while we would always want to think that justice is equivalent to winning your case, it's not always the case that our clients are always right. So if you pin your preparation to that, you won't be arrogant, because you really wouldn't know. You only always know half of the story when you handle a case, until you hear the arguments of the other side. That's when you realize, and you keep an open mind, wait a minute, there might be something there that was not shared with me by my client or by my collaborating counsel. So I think it's important to always keep an open mind and be humble. You're there, of course, to impress the client. But at the end of the day, you're also there to convince the arbitrators. And I noticed that arbitrators don't really like someone who's arrogant, who tries to browbeat a witness or opposing counsel. There really has to be that semblance of humility and respect, not just for opposing counsel, but also for witnesses. Because you don't really know whether you're right. We all believe we're right when we're handling a case, but let's keep an open mind. Sometimes the other side, if there are 10 issues, there might be some 2 or 3 issues that your client may be wrong. And keeping an open mind perhaps will keep us also humble, whether as arbitrators or advocates, in handling a case.
Yes, I think sometimes, when we spend years working on a case, we really believe in our case, and sometimes we can lose sight.
Yes. Your client can never wrong. The one who pays your fees can never be wrong, right?
Yes. So, what do you, in situations where, we are aware of perhaps the weak areas in our case, or areas where the clients might be wrong, what's your advice on what we should do in those situations? Because we're still trying to win a case, right?
Mm-hmm. Again, I this is a personal thing to me. This is not a judgment on other people's preferences. But I always believe that even if you have certain claims or arguments that are weak, you just have to be candid about it and still study, because at some point you might think it's weak, but there are other angles that you will see that if you look at this angle, it's actually going to be strong. Or just come out in the open. We don't think that's a very strong argument, but we believe there is an argument there. And in any case, the main issues here are this. You can't always pretend, because sometimes it also impacts your credibility. Arbitrators, the beauty with arbitration, especially in international commercial arbitration, is that as long as you choose the right arbitrators, these are competent people. These are people who will pore over your files, and they will know, they will have, entering into a hearing, they will already know which issues are weak or strong for both parties. So it's I think it's just a matter of being candid at times. And if it's really a very important matter and you feel you're weak on it, then perhaps you should focus on the facts. And if you feel you're weak on the facts, then probably focus on the law, the substantive law. But you know, you cannot say with all honesty and with a straight face, unless you're really that good. I find it hard to do that. I will always be upfront. I will say, yes, we believe in our argument, but if the tribunal feels it's a weak argument, then we respect that. And then I just explain why.
Yes, I think as you mentioned, building your credibility before a tribunal is sometimes, if not the most important thing that we as counsel should really emphasize on. And it's by addressing the weak point that I think we do get to build that credibility in the most effective way.
Mm-hmm.
Yeah, and you know, in your answer, you mentioned about first time that you get to do oral argument before a court or a tribunal. Do you still remember your first time doing an oral argument before either a court or arbitral tribunal?
Well, that's interesting because I'd probably relate my most memorable oral argument in litigation as similar to my experience in my first oral argument before an arbitral tribunal. When I first already argued before the Philippine Supreme Court, the Supreme Court in the Philippines is the highest court, and they rarely hold oral arguments. I was then an associate in Romulo. The oral arguments were set on a Tuesday, I remember, 1:30 p.m. of June 26. I remember the date very well because I was not supposed to do the oral arguments because it was the Supreme Court and bank. All 15 justices were there and they were going to grill you. And then I got a call from the partner on a Sunday, which is 2 days before the oral argument. And then the partner goes, Louie, we just received a call from a client and they were saying, could you be the one to do the oral argument on Tuesday? And you have to understand that this was almost a year of preparation. And then the client says on a Sunday, 2 days before oral argument, which is 1:30 p.m., which leaves me with just Monday to prepare and eat up into my Sunday to do it.
And how many years have you practiced at that time? Were you a senior associate?
I think I have practiced for 4-5 years. Probably thereabouts. And then and it was really scary because I told the senior partner, you know, it's not fair. It might not be fair to the client because I'm an associate. I will only have 2 days to prepare for this. And the senior partner said, well, unfortunately for you, Louie, it was the decision of the client for you to do it. So jump to arbitration. Again, I was not supposed to do oral argument. And we had an international counsel. And then the night before the closing arguments, because that's when the tribunal will be asking questions.
Yeah.
The night before closing arguments, our international counsel said, Louie, why don't you do the closing arguments on Philippine law? And so I said, I don't think it will be fair to the client. Actually, I think it is because they were the ones who also said, you should be the one to orally argue or do the closing arguments. So again, I had very little preparation. And I think the thing that boosts a person's confidence in situations like that is that you can never go wrong because you were given only very little time to prepare. It was the call of the client. And so you just have to grin and bear it and just, you know, again, lose sleep over it. But at the end of the day, it turned out okay. Well, fortunately, the Supreme Court case, we won the case. And in that same case, we also won the arbitration. Not because of me. It was because of, I think for that arbitration, it was the International Council. But at least, you know, it boosts from a young lawyer's perspective, it boosts your confidence. Now I can do oral arguments. Because if I can do it overnight, just imagine what you can do if you had months or years of preparation.
Wow, that's amazing. But now, now having had more years of experience as oral advocate before both court and arbitral tribunals, what would you say are the keys to effective advocacy? And in addition to that, what can young practitioners do to best develop those skills?
Okay. I think the most, for young lawyers, I think the most important thing at the start of your career will really be meticulousness and observation. I think we should not be, a young lawyer should not be thinking, I want to orally argue, you spend those years watching and observing people who you think are good advocates. Because the key to good advocacy is really preparation. Anyone who tells you otherwise is lying. You cannot be a good advocate, you cannot be a credible advocate if you do not know the facts of your case. I have seen really experienced and supposedly well-known lawyers internationally who, when they were orally arguing and they were being asked by the tribunal questions, they would turn to someone to their side and then would pause for a long time and ask, what's the answer to that? Essentially, that was what they were doing. And I think if you want to be a good advocate, you have to be able to convince a tribunal that what you're saying is true and is correct and is a product of study and the facts. And if you cannot recite the facts and you cannot recite the law, then people will think that you're mouthing only what is good for your client. Arbitration is supposed to be enlightening the tribunal with the facts and the applicable law. And the only way you can do that as an advocate is if you know those facts and the law.
Yes, and I think that goes back to the credibility point that we talked about, that
yes,
that's key to build your credibility before the court and tribunal. Yeah. And as we've already talked about, you, in addition to your arbitration experience, you have also had very significant litigation experience, and you've handled various disputes before the courts and including the Supreme Court in the Philippines. I want to ask you, do you find the experience practicing domestic litigation to be very different than arbitration? And if so, what are the main differences?
Okay, I think the good thing about doing litigation, because I did litigation before I went into arbitration, it doesn't have to be that way. But what I do notice is that for those who have been doing litigation, it develops an instinct. It develops the instinct that you will also need in arbitration, because at the end of the day, both are dispute resolution mechanisms. And the main difference really is with respect to procedure. Litigation is very, at least the Philippines adopts the American system. The Supreme Court even quotes Wigmore on evidence up to now. And with litigation, there are very strict rules on evidence. Yeah. And you can object to admissibility of evidence on the ground of it is not an original copy, it is not the best evidence of the document. In arbitration, it's not really that way. As long as the document is credible and unless someone questions it, the tribunal will allow it. There will be a difference on the probative value they will give to it, but more often than not, they will allow it as long as it's something that is produced within the timetable allowed by the tribunal. So, and even in the conduct of cross-examination. In cross-examination, in litigation, when you object on the basis of the rules and evidence, like that's hearsay, that the witness is incompetent, and so on and so forth. I rarely, I don't even remember me using that for the longest time in an arbitration proceeding. Because, of course, if you are seen to be someone relying on technicalities just to shield your witness from a question that appears appropriate and is relevant, but you're relying on technicalities, you might be sending the wrong signal to the arbitrators that your witness is actually incapable of answering truthfully or competently on a question that is relevant. So I think that's really the nuances I see between litigation and arbitration. But insofar as my experience, at least for those in the Philippines, and for those who probably share the same culture as the Philippines, I find arbitration more exciting because you're not just up against sometimes international counsel, which would have like sometimes we've been up against international counsel who have 6,000 lawyers in their arsenal, and their team handling the case is, for just one case, is even bigger than our entire arbitration department, and it allows you to pit your advocacy, your industry, your meticulousness with that kind of team. And I think that's exciting. That to me is an exciting area of practice that helps me wake up in the morning, even at this stage, excited about my cases.
Yes, I think many of us will share the same on this webinar, share the same passion for arbitration. And do you find throughout the years, you are getting more work in arbitration? Has there been an increase in international arbitration with the Filipino nexus that has kept you busy?
I think, there is a difference between quantity and quality of time spent. The quantity of cases vis-a-vis the quantity of time you spend. That's what I mean. So in litigation in the Philippines, sometimes the hearings are reset for long periods of time. Although there has been an amendment that was passed in the rules of civil procedure last year to try to expedite hearings. But in terms of actual practice, sometimes the hearings are really reset for a week, a month, 2 months. Whereas in arbitration, once you've set the hearings, a 1 month hearing, 2 week hearing, you will really be hearing every day for those 2 weeks. So for me, it's that kind of difference between litigation and arbitration, where your hearings are a bit more rigid in arbitration. It's literally continuous hearings, which you don't really experience in litigation in the Philippines. I know that in some jurisdictions they also have continuous hearings. You'll have hearings for a whole week. In the Philippines, that doesn't happen. Your next hearing will probably be reset for 2 weeks, sometimes 2 months, sometimes 3 months after. So that's something that is quite different.
Yes, and so just in terms of the volume of arbitration that you've done in recent years compared to when you first started, there's a general increase in the volume of arbitration cases arising in Asia. Have you seen that reflected in your work?
Oh yes. Sorry, I missed that part. Yes, it has significantly increased. Again, I think because it's a function of the institutional changes that were passed by Congress, Philippine Congress, and also by our Supreme Court. So we've been lucky to get a volume of arbitration work. In arbitration, when I'm personally handling easily over 10 arbitrations, half of which I picked up over the course of the pandemic, and the rest were spillovers post-pandemic. The others have been already concluded. But there is a constant stream of arbitration matters coming in. in the Philippines. There is also, of course, there will always be a stream of litigation, but the quality of the arbitration work that is finding its way in the Philippines is actually very good. And it is, I think, a function of arbitral institutions becoming more active in promoting arbitration in the Philippines. We have HK45, SIAC, ICC, the Kuala Lumpur Arbitration Center. They do a lot of business development work, which I think is important. You'll be surprised. Some of the big companies in the Philippines, sometimes they're still unfamiliar with arbitration. They don't know that you can actually do an HKIAC arbitration in the Philippines. They think that when you say HKIAC, it has to be in Hong Kong. So, and education by these arbitral institutions and even by lawyers. And I think it is also incumbent upon young lawyers, especially those who are advocates of arbitration, it is our obligation to educate our clients. And that has increased, I think, the volume of arbitration work that is finding its way in the Philippines. I find my time probably around 80% doing arbitration and 20% litigation. But in terms of number, I have more litigation work. It's just that because of that calendaring of activities, you find you know, Kitty, that when you handle one arbitration, it's actually probably as heavy as 5 litigation cases. So at least for the Philippines, it's really like that. So that's how I see arbitration developing in the Philippines.
Yes. And just related to the topic, I want to ask you if you can change one thing about arbitration in the Philippines, what would that be?
It would have been easily a cop out, but our arbitration really needs a lot of improvement, but it's getting there. But if there's one, I'd probably choose 2 if you will allow me. One
Sure.
is how to deal with interim measures of protection. I think there is a lot of improvement, especially in terms of how judges approach interim measures of protection in support of arbitration. I have encountered situations where it's just an interim measure and the judge will end up invalidating the arbitration agreement, or an interim measure of protection which actually tries to restrain the arbitration process. I think the law is very clear, not just in the UNCITRAL model law, but also under Philippine law, that interim measures of protection are just really to maintain the status quo, with the competence to resolve the dispute still lodged with the arbitral tribunal or the sole arbitrator. And I think we need a lot of improvement in that regard, that we have to learn to respect the purpose and objective of interim measures. They are supposed to support arbitration and the parties' preference to resolve their dispute to arbitration. It should not be a means of one party allowing the dispute to be resolved in court. That's not what interim measures are. And again, the second one is really enforcement and refusal of recognition. I think there should be more respect given to arbitrators. That's why it's important to have credible arbitrators appointed, because it will also help in foreclosing recourse to courts when it comes to enforcement, setting aside or refusal of recognition. So I think those 2 areas are still need a lot of improvement in the Philippines. We're getting there, but it still needs a lot of improvement.
Yeah, I think the role of the court and how supportive of arbitration they are is a common issue in different jurisdictions. I think you are telling me with the passage of the ADR law in the Philippines, the court has becoming more supportive and more acceptive and more understanding of the arbitration process. it sounds like even with the improvement, there's still further improvement that can be made.
That's correct. That is correct.
Yes. I want to move on to a slightly different but related topic. There has been a lot of discussion around diversity, and namely diversifying those players involved in the field of arbitration. And one aspect is cultural background. And we talked about with the increasing volume of arbitration cases in Asia, there's obviously a growing demand from Asia-based clients. And do you see a corresponding demand for more diverse counsel, more diverse arbitral tribunals?
Yes, and I think it's very crucial that we do recognize that and address that, because culture sometimes is also the root of disputes. Especially international commercial arbitrations that I've handled, most of the disputes, I think, really arose out of cultural misunderstanding or cultural misconceptions. In one case I handled some years back, the international counsel, when he was cross-examining one of the witnesses who was of Asian background, he commented to me when we were in the breakout room, "Did you see that, Louis? I mean, the witness couldn't even look me in the eye or the tribunal in the eye." And so I had to say, well, that's true, but we have to also take into account that, the witness is from this Asian background, and I understand that in that kind of background, looking a person in the eye can be actually disrespectful. I'm not saying that's how the witness was thinking, but it is important that we do not attribute a person's facial expression, where the person looks, how the person answers, as a barometer for credibility or truth. I just remember one of the books I just finished reading was Talking to Strangers by Malcolm Gladwell. And he makes a very important point about people judging other people. Lawyers sometimes tend to think that, when I want to cross-examine a person face-to-face so that I can tell whether that person is lying or not. You have to account, I think, for cultures also. And that goes for arbitrators. Of course, the more sophisticated and experienced arbitrators, regardless of their cultural background, would have already gone beyond that issue. But the problem with it becomes we become a victim of the successes of successful arbitrators. Because when you become a successful arbitrator, your calendar also gets filled up. And that means that the calendar and length of time of the arbitration procedure sometimes suffers. And if we allow for diversity, because there are a lot of equally brilliant, hardworking, and very credible arbitrators in our region, in Asia, and it's just a matter of knowing them, vetting them, and for counsel, actually vouching for them after your due diligence. Sometimes we fall into that trap of going the easy way out. To cover our behinds, we will look at who are the top arbitrators, and then when the client asks for, can you give me 5 or 6 nominees, then you go for who are the top arbitrators. I mean, yes, that's a safe one, but you also have to look at how will this impact on the calendar? How will this impact in terms of cost for my client? And you would also have to look at it is incumbent upon us as lawyers, whether young lawyers or experienced lawyers, to try to nominate a good mix, male and female, because we cannot always rely on the males. We males do not have a monopoly of justice. I have my wife to prove that for our 24 years of marriage. So I think we need to also make sure that as advocates, if we are on that side of the fence, if we really are for diversity, we make sure that when we fill up that list, let's not take the easy way out. Let's also put in a good mix. Let's put our money where our mouth is. We try to do that. We put in male and female names. Unfortunately, our forms, for example, we don't have forms which would reflect the LGBTQ plus preferences. So perhaps the HKIAC and other institutions should also address that. If we are really going for genuine diversity, then the form should also reflect that. And let's not be stuck up with old forms where there's just male and female to describe the arbitrators when they give their CVs. So, or probably just take it out. But if we want that diversity, then perhaps we can also look into that angle. Again, that's just me throwing ideas into the wind. But again, there is much to develop, I think, especially in our part of the world, insofar as diversity is concerned. And it is incumbent upon all of us, both arbitrators and advocates, to really push for that.
Yes, you've touched on so many different important aspects of diversity, because I asked you about cultural diversity, but of course there's only one aspect there, and you touch on different age, gender, sexual orientation, and that is really the main topic of our Fire Chat series, is to talk about diversity in a broader sense. You mentioned as counsel and as arbitral institutions, we can play our parts to do more to promote diversity. Is there any other barriers or major challenges that you see that currently existing that is preventing the field from achieving more diversity as is needed?
I think we just really have to adopt that paradigm shift. Let's not fall into that, as I said, cop out of just looking at the list of arbitrators who are the most renowned. It's, I think, the barrier really is sometimes our own clients. And I think we should play a more proactive role there and tell them, educate them that, a lot of arbitral institutions now are actually encouraging diversity in terms of cultures, in terms of sexual preference, in terms of age, and explain to our clients what the benefits are of diversity. For example, I handled an arbitration as an advocate where my client's nominee, I came in, there was already an arbitrator, and my client's nominee was a young and very promising and really well-known also arbitrator. And the nominee of the other side was a very well-known and very senior arbitrator. And then the president of the tribunal was somewhere in between. But during the course of the hearings, you can see the senior respected arbitrator sometimes dozing off during oral arguments, whereas the nominee of my client was engaging with the counsel and also with the president of the tribunal. So for me, those are things that we can explain to our clients, why it is beneficial to also consider diversity, because there are benefits. It is not just an advocacy because we believe it, but there is a reason why institutions are pushing for it, because it does give benefit to the end users. And so we have to be the ones to push for that and educate our clients, who are sometimes the barriers to development of diversity.
Yeah, I think that's a very, very good point. And I'm just saying the Q&A session on the topic of diversity related question. Someone asked, did you ever feel like you had to work harder to be recognized or seen in international arbitration as compared to co-counsel or opposing counsel or other co-arbitrators who are from a more traditional arbitral jurisdiction, such as the UK, France, etc.?
Oh, I think it's also a mindset. I think it's unavoidable that we feel sometimes that way, especially during the early stages of my career in arbitration, where you enter a room, and of course, again, it's more informal, right? The arbitral tribunal will greet everyone, will say hi, and probably shake your hand, and so on. And then you hear them calling opposing counsel who is from an international law firm or from the Western territories by their first name. And then they come to you and say, so sorry, I am this, you are, you know, and you immediately feel that there is that familiarity between the arbitrators and the opposing counsel who come from the same jurisdiction. And in fairness to them, that is not their fault. But again, that is a function of who appointed these arbitrators and these counsel. So yes, I think it is inevitable, but eventually I think it is something that can be remedied. And especially, again, the more sophisticated and experienced arbitrators will know. I make it a point to try to determine who are these arbitrators, who are these lawyers that who are parties to the case, so that you because I know how it felt, and you want to avoid other people feeling that way when you're the one introducing yourself. So I think, again, it's not the fault of the arbitrators or of the opposing counsel, but it is inevitable, I think. I think, at least from my experience.
Yeah, that's good advice. And I have another question. If you could practice anywhere else, where would it be and why? Or is there anywhere else you have liked to have started your career? Because there's many young lawyers move through jurisdictions in quite a nimble way these days. It is a good thing.
I've actually, especially when I was an associate, in fact, even when I was a partner, because the international counsel I was working with probably thought I was still an associate. I've had my fair share of offers to join foreign firms, but I still prefer practicing in the Philippines, especially since, in my mind, I'm practicing international arbitration already anyway. Why do I have to transfer? But if I were to choose a second favorite place to practice, I would say Hong Kong or Singapore, if only because I find myself closer to home, but at the same time, English is I would have easily said.
Be careful. I'm sorry, this is Duncan, but you also have a very young colleague of mine, my toddler Theo, who accidentally pressed unmute. So I'm sorry for interrupting.
Okay, no problem, no problem. So I think it's because more and more these seats or these places of arbitration in our part of Asia are inviting really a very good mix of arbitration cases and arbitration practitioners. And it's really very exciting. I find it a very exciting area and place to be doing international arbitration, especially for young lawyers at this time, you know, Hong Kong and Singapore. And it's only for that. I'm not saying that those two places are also not good places for eating and shopping, but it's really that. It's the mix and the type of cases and the type of people you find yourself collaborating with, working against. These are things that keep our profession exciting.
Yes, and I can't speak for everyone, but I'm sure you'll be very welcomed in Hong Kong, especially.
Thank you.
Yes. Let me just cover the one last question from the participants. You mentioned about staying humble in your advice to young practitioners. This person asked, how do you handle younger lawyers who are perhaps lacking humility, and what sort of feedback can be given in those situations?
I don't like. I tolerate it. I actually tolerate it because we can never tell what that person is going through. Some people who are new in the field tend to react with their own insecurities by trying to mask it and look too confident that it already sounds arrogant. But it's not their fault, again. So I guess the best way to enlighten that person, or at least invite them to your perspective, is still by example. You cannot browbeat a young lawyer who is arrogant just because you know better. I think in fact, on the contrary, it might help, because that's really how I've also learned as a young lawyer. I've seen really very experienced arbitrators, international counsel, and Philippine lawyers who are well recognized, not just in the Philippines, but all over the world. And when you go against them, it's as if they're associates. They rely on the strength of their case, and they're very humble. And that was the thing that made me admire them and respect them all the more. So, and that was what taught me. So I said, when I advance in my career, I want to be like that person. And so you just pass it on. You pay it forward, right? If you learn from that person, then hopefully when you get to that point, I'm not yet at that point, but as you get closer to that point, where you are closer to the people you admire, then don't forget that you also have to pay it forward, because these young lawyers will also become better lawyers by your example.
Yeah, thank you so much, Louis, for this very inspiring and also fun-filled conversation. And I'm sure I speak on behalf of everyone who has been listening to our chat, that it's been very informative. And I hope you have enjoyed our conversation as much as we have enjoyed your wisdom.
It was a pleasure. This is one of the fun conversations I've had on arbitration, especially since I think that the young people are really the hope, not of the future, but especially of arbitration. So it's always good to start off with something like this, to be able to share experiences in a very relaxed and fun way. And thank you to HK45 for inviting me. It is a privilege and a pleasure.
Thank you very much, Louise, and again, thank you for everyone who has dialed in on this Friday afternoon. And I hope everyone would stay well and safe in this uncertain times. And have a good weekend.
Okay, thank you, everyone. Thanks for your time. Thanks, Kitty.